Happy Friday. As many of you know, I am Candace Wagner. I am the Continuing Education and Special Programs Coordinator for the Wisconsin Dental Association, and we are absolutely delighted that you are able to take time to join us today. Hopefully it's over your lunch hour or you have the rest of the day off. But either way, we're happy that you are here. And we are very excited to have CLA and their support, and we look forward to hearing everything they have to say about human resources today. As a reminder, this presentation is going to be recorded, so we ask that you keep your computers muted. They should be muted already, so if you could just keep them that way, that'd be great. And make sure your video is turned off. And we also encourage you to use the chat box at any time to answer questions. Kim and the team are going to be great as trying to pause and answer questions accordingly. So feel free to pop into the chat box. And if we can't get to your question today, if we happen to run out of time, the CLA team is more than willing to follow up with any of your questions after the presentation today. So that's very gracious of them to do that. Without further ado, I'm going to introduce Kim Orselitz. She is the principal at CLA's outsourcing practice and provides guidance to business leaders on human capital matters such as compliance and regulatory issues, employee relations, staffing and retention, performance management, and overall human resource strategy. So without further ado, thanks, Kim. Go ahead and take it away.
Great. Thanks, Candace. And thank you, everybody, for joining us today. We really appreciate you being here. And it's an honor for me to be able to speak to WDA and BizTalks. So we're going to cover a lot of material today. Again, it's going to be recorded, and we will try to answer questions. If you have general questions, please put them in the chat box. If there's specific questions to your practice, obviously we can't answer those over a live stream because there may be confidential information, but I'm happy to talk with you offline about some things that may be impacting your human resources and people practices. So we are going to go through a quick agenda. I'm going to share with you what we're going to talk about. But first, I need to put up the disclaimer. A couple of things that we want to share with the team is that CLA can't provide legal advice. I'm not an attorney. I'm a certified HR professional providing best practice related to human resources. The other thing I want to share is this is an overview of labor and employment law and some key HR programs and practices, specifically federal labor and employment law. So there are state-specific labor and employment laws that impact organizations. And as I was preparing for the presentation, I reviewed some of the Wisconsin labor and employment laws. And good news is Wisconsin typically follows pretty much the federal labor and employment laws. So there's not a lot of outliers there, such as like states like California or Massachusetts that really have a lot of their own labor and employment laws that impact employees. So with that said, if there is a difference in labor and employment law from a state or a federal perspective, the one that is most generous is what the employer should implement and should go by. So that is part of our disclaimer, and just want to move into the presentation now. So our agenda, like I said, going to go over some key labor and employment laws federally, share with you some things that you should be aware of, talk about record keeping requirements, then the importance of onboarding and offboarding and checklists, and then give you some time for some Q&A at the end if we have some opportunity there. So I thought it was appropriate to throw out a word cloud because we have so many labor and employment laws. And the goal here today for me is to share with you some information as business owners, employers, and practitioners, what you need to know. And as I was thinking about the presentation, I kind of scratched my head and I said, wow, what do I need to know about dentistry? I need to know that I have a dentist, that I like the dentist, that I trust my dentist, and I need to know about my own personal care. But above that, I probably really don't need to know anything. I would call my dentist and see a professional. But with labor and employment laws, as employers, that's different. You really do need to know and understand some things about labor and employment law, because not knowing is not a defense. So as an employer, you have to file taxes. You also need to know about labor and employment law. And so that's the goal here today, is to give some broad overviews of labor and employment law, so you can say, okay, I remembered Kim talking about this. Maybe I need to get some research or talk to somebody else that may have some more knowledge about it. So come in it with that, from that lens. The goal is to learn. I'm not expecting you to walk out of here and be able to quote when a law was enacted. I probably don't even know that any longer. But I know that there's something out there and I probably need to research it. So the word cloud is kind of out there to show how confusing labor and employment law can be and how many of them there are. And we're going to touch on some of those today. So let's get started. So a lot of acronyms when you see labor and employment law. And so we're going to go through these at a high level and talk about what they mean to you as an organization and as a dental practice and as an employer. So the ADA, the Americans with Disability Act, is for covered employers. And when I say covered employers, key labor and employment laws are enacted based on basically the number of employees that you have on staff. So the ADA is over 20 employees. And what does that mean? It means you can't discriminate in your employment practices against somebody that has a disability and is otherwise qualified to perform those essential functions of that job. And so, and further, what does that mean to you as the business owner? If an employee may have a disability and they ask for an accommodation, it's your responsibility to determine and have a real conversation about considerations of what may make that job accessible for that employee to accomplish with a reasonable accommodation. So really being open and honest if somebody comes to you and says, hey, I have this disability and I can't perform this function of my job. How can we get around that? And having that conversation and documenting that. That's what the ADA, the purpose of that is. The next act, another acronym, is ADEA, the Age Discrimination in Employment Act. And so we talk about protected classes in HR, and age is a protected class. And I'll give everybody a prize, anybody that can put what the protected class is in the chat box. Really, it's not a prize, it would be bragging rights. But if you happen to know what the age protected class would be, put it in the chat box and let's see if somebody may know that. I don't see any chat there. So what is the Age Discrimination Act? Believe it or not, if you are over 40, you are considered to be in a protected class. So us individuals like myself that are over 40, I'm considered a protected class, and employers cannot discriminate against an employee based on their age. So that is what the ADEA means. Title VII, the Civil Rights Act. So this one is really what I like to refer to as the granddaddy of all employment acts. And why do I say that? It really is the legislation that was enacted in the 60s that started all of the protected classes. As you heard me say about age, there's other protected classes, and employers need to understand that these protected classes, any employment practices and decisions that are being made cannot be discriminatory because of the protected class. So what are some of the protected classes? Age, gender, race, ethnicity, national origin, disability, as we talked about. And then recently, the laws were changed to encompass sexual orientation. That was, believe it or not, we all thought it was a protected class until just recently the federal law changed that, and now gender identity and sexual orientation is considered a protected class. So when we say they're protected classes, what does that mean to you? Cannot make employment decisions that are related to those protected classes, and that could potentially be seen as discriminatory. Does not mean that you cannot make employment decisions, but they should be based on the true meaning of the job, the responsibilities of the role, and situations that have to do with your business and your practice, and not to do with somebody's race, gender, age. Those are not deciding or decision-making factors in your business decisions and employment practices. The next one is the Fair Labor Standards Act, or FLSA. So I will even admit, as an HR professional, this is probably the most complicated employment act of all the acts that are out there, and it does impact every employer. And the difference with this act is the employer has the burden of proof here. You have to have this right. You have to document things appropriately with record keeping. You have to classify individuals appropriately. Where the other discriminatory acts, the employee has the burden of proof to show that they were harmed. Under the Fair Labor Standards Act, it's the employer's burden of proof. So what's the Fair Labor Standards Act? You may know it as the law that governs minimum wage, overtime regulations, child labor laws, record keeping, whether an employee is an exempt or non-exempt employee or eligible for overtime. That's what the Fair Labor Standards Act is. And it was in the news quite a bit over the last several years because there's been some changes in that act based on the salary threshold for exempt employees. So let me back up a moment about the FLSA. What does that mean to you? One, you have to pay minimum wage to hourly or non-exempt employees. Minimum wage is $7.25 an hour federally. And then in Wisconsin, it's also $7.25. I'm sure you've seen on the news that states have been enacting higher minimum wages. I sit in Florida and we just voted in a minimum wage over a gradual implementation to $15 an hour. And we're seeing more of that happening in different states. But Wisconsin follows the FLSA. The second thing to know about FLSA for you is if an employee works over 40 hours in a work week, then they're eligible for time and a half overtime compensation. So that is important with record keeping and timekeeping. And then the last thing is really how to classify an employee. And you heard me say exempt and non-exempt. What does that mean? Non-exempt means hourly employee. You pay them at an hourly rate and then overtime above that 40 hours. Exempt, some people think is similar to salaried, but it really isn't. To be an exempt employee, there's a duties test that is required by the Fair Labor Standards Act. It really is contingent upon the roles and responsibilities they perform for the organization, that they are also paid a salary. And the recent change last January in the salary threshold is that employee is paid a minimum of $684 a week to be exempt. So there's a lot rolled up in the Fair Labor Standards Act. And I really encourage you, if you're thinking that you may have classification concerns with how you've got individuals classified, an office manager or something like that, that you really look at the act or you reach out to someone that's knowledgeable with it so you do not have people classified inappropriately. So those are some key acts. We're going to move on to some more. FMLA, or the Family and Medical Leave Act. As you heard me say, key numbers of employees trigger different labor and employment acts. Well, that's one the FMLA does. If you have over 50 employees, you have to have an FMLA process and policy. And what does that mean? It means that you will allow employees to take up to 12 weeks off unpaid of protected leave if they need to be out for an illness of themselves or a family member. Of course, they have to qualify for this leave, and there's a process to take place, paperwork to fill out, doctor's notices potentially to approve the leave. But just know that it's a requirement if you have over 50 employees. I also checked Wisconsin state law, and it doesn't appear that Wisconsin has an individual paid leave or a state FMLA at this point, but always be on the lookout for those changes because there's a lot of legislation around the country changing that. ERISA, the Employee Retirement and Income Security Act. And you probably are going, well, what does that mean? We may not provide a retirement plan to our employees. Well, it's a little bit broader than that. As an employer, if you provide group benefits to your employee base, such as health insurance, dental insurance, maybe flexible spending accounts, or a retirement plan, ERISA governs those group health insurance wellness plans and your retirement plans. And what do I mean by govern them? ERISA sets criteria for employers to provide certain documentation to employees related to that group plan. And that documentation needs to spell out enrollment and eligibility, so employees would have access to that information, and also to ensure that employers are applying your enrollment and eligibility consistently. It also sets out their information of that notices that have to be sent to employees annually. So maybe when you're going through your open enrollment process, your insurance vendor or your agent is saying these are notices that need to go out to employees about Medicare and other types of things. That is all rolled up under ERISA, and it can be pretty complex, but just know that there are consistency requirements in your group plans, and employees should be eligible for the plan, and it should be consistently followed as you enroll and terminate people from any group plans. The next one is the EPA, or the Equal Pay Act. It is an add-on to the Title VII Act of discrimination, and it really is what it says. Employers cannot discriminate in compensation or pay based on gender. And so what does that mean? It's important that employers look at similar job positions and job functions, and then look at their demographics of their workforce to see, am I paying male and females that do similar jobs the same? And if I'm not, why? And you can, but there should be reasons. It may be tenure, it may be performance, it may be education. So knowing that and documenting it and being able to tell that story is important. But the Equal Pay Act you're seeing in the news as well, because many states are implementing, again, an Equal Pay Act where they're requiring employers to go in and verify and do more of a self or a mini audit on these pay practices to ensure there's not discrimination. And larger employers that are over 100 need to report this information to the government on an EEO-1 form, is called. So if you're over 100 employees in your practice or a group of practices, that EEO-1 form is important, and that is reporting demographics of your workforce and pay. I threw the FFCRA on here as well. Everybody's probably heard about this this year. It's the Family First Coronavirus Response Act. And we've all kind of been in a whirlwind this year with COVID-19, not only I'm sure from your personal practices, understanding OSHA and CDC guidelines, but then the employer required requirements under FFCRA. And what is that? First, I want to note that this law currently is to sunset at the end of this year. So December 31st, this law is potentially going away. Of course, we hear legislation is out there trying to extend it because we know coronavirus is still active in our communities, and we're trying to prevent the spread. But really, the FFCRA is out there to protect employees and allow them to have some time off, paid time off, so that if they become infected or exposed to COVID-19, they're not coming back in the workplace. It allows them up to 2 weeks paid time off so that they are not spreading the virus in the workplace. And I know that there's some exemptions out there as well for healthcare providers. And if you've looked at those, some of your practices may qualify for those. But just know that you should be reviewing that information and posting those notices and ensuring employees understand the rights under the FFCRA. Some more alphabet soup here. We've got some other acts that you may be aware of, that the Immigration Reform and Control Act, those are our I-9 forms, and those are forms that are completed when people are hired for employers to ensure that they're eligible to work in the United States. So all of you, I'm sure, go through that process where you ask an employee to complete that form within 3 days of hire. You're looking at the supporting documentation and signing off that you've reviewed that and retaining those documents. The purpose of that is truly to ensure that the person is who they say they are, and then that they're eligible to work in the United States. And you should have an I-9 form on all employees within your workforce. The next one is OSHA. I'm sure as dentists and healthcare practitioners, you know OSHA from a safety perspective in your workforce. They set a lot of guidelines around how you can practice dentistry, but also they set guidelines around safety for employees. And essentially, OSHA is saying that employees have a right to work in a safe environment that's hazard-free, and it sets some guidelines around there for employers on what would be considered hazards and reporting requirements. So be comfortable with that and understanding that. COBRA, the Consolidated Omnibus Reconciliation Act, which is a mouthful. That is for individuals who have group health insurance, dental insurance, vision insurance, any of those wellness benefits, to be able to continue coverage on the same type of a plan if they have a qualifying event or if they leave your employment. And so COBRA, the state of Wisconsin, even if you may not meet the COBRA, the 20 people or more to be a COBRA covered employer federally, Wisconsin has a mini COBRA, we call it, act where all employers that offer group health insurance benefits and wellness benefits should be offering COBRA to employees that are leaving the organization. Again, there's paperwork to fill out. Employees that want to elect COBRA need to actually elect it and pay their premiums, but it is a responsibility of the employer to ensure that that exiting employee gets that information so they can apply for that coverage. HIPAA, probably another term that you're familiar with from a dental practice perspective, where you're protecting private information of your patients. It also pertains to employees. So if you have information and data about employees' private health information, or information about their elections of their benefits, if you learn something about an employee because they're because of a work comp situation, or they're requesting leave under the Family Medical Leave Act, that information needs to be protected and by you as the employer and not shared with other individuals. So I got a great example that I was thinking about that I want to share because it still makes me laugh a little, but it kind of hits home. I'm on a office-wide distribution list for a client because I act as their HR director. And one of their employees called in sick to the front desk, and the person at the front desk sent out an email. It's their practice to say, you know, who's going to be in the office, who's not going to be there that day. And they sent an email out and saying, Janie's not going to be here. Her high blood pressure's up again. And I got that email and I laughed a little bit at first. And then I said, okay, we need to have some conversation around what to share and what not to share. And obviously that was inappropriate to share somebody else's health information with the entire office. Now, if the employee wants to share that, that's absolutely their preference, but it should not come from the employer. So kind of a fun example. Well, maybe not so fun for that person who the information was shared, but kind of an example of what not to share. And then another act is called GINA, and GINA is the Genetic Information and Non-Discrimination Act. And you scratch your head and you're probably like, well, what does that mean? Well, it means that employers can't discriminate against employees for any genetic information they may have. And you may say, well, I don't collect genetic information. But I bring it up because some employers have wellness programs where they require employees to go out and maybe do the know your numbers, you know your cholesterol, know your sugar and those type of numbers. And so if that information is shared with the employer and the employer knows that, you cannot discriminate against an employee because of that information. So that's kind of the reason why I throw that out there and want folks to understand that you do have private information, you're collecting information, and if it doesn't pertain to their actual function in their job, that should be safeguarded and not shared and not used as employment consideration. I've shared a lot about some major labor and employment laws, and we haven't even scratched the surface. There's many other laws out there that pertain to employers, as far as background screening and credit checks. And you've probably heard obviously on the news about the ACA, or the Affordable Care Act. If you're over 50 employees, you have to provide health insurance to your workforce. So there is a host of other labor and employment laws that are out there. And then again, there may be some specific to your state or your municipality that you should be aware of as an employer, and a dental practitioner. And I say all of these labor and employment laws, one, because everybody wants to try to be in compliance, of course, but until you understand labor and employment laws and are in compliance, you can't take the next step to be an employer of choice. And we all want to be an employer of choice. We want to hire and retain great talent, and we want employees to talk about what a great place we have to work and share with patients and maybe other individuals that may want to come work, or even on social media. So it starts with understanding employees' rights and how that may affect your employment decisions before you can step up and be that employer of choice, where employees say, wow, they really treat people great. They consider, the impact of the decisions they're making, and we have some transparent conversation. So all that said, there's a lot of activity in labor and employment law, and with the change in administration, potentially we'll see some different acts out there. I do anticipate that we'll see some more activity around the coronavirus, and maybe some more relief in labor and employment laws for employees around that. So stay tuned to that information. Couple other things to mention about labor and employment laws. All those acts that I shared with you also have record-keeping requirements, and they do vary by the different acts. And so what I would encourage you to do is have a record retention policy, understand which records need to be kept and for how long, and really have a policy around it, and have somebody dedicated to understanding that. The minimum you would keep information, your hiring documentation and your selection information, like applications and resumes, are a year, and then other information up to 6 years. Under ERISA, that could be your medical elections, your dental elections, any 401k or retirement information, a minimum of 6 years for that. And then also thinking about if there's any lawsuits or allegations against the organization, having that record retention policy to retain those records to defend yourself in any claims is important. And then lastly, thinking about your vendors that you work with. If you have a payroll vendor, are they in compliance, and are they the ones housing your payroll records, and do they understand the compliance, and do they have that data saved for you so you can easily access it if you have the request from a compliance perspective? So looking at those vendors and make sure that they understand the record keeping requirements, and that they are retaining your records for you. So before we move into the, well, I've got one more slide on this section, and then we'll see if there's any questions. One last thing about the labor and employment laws: there's a host of posters and notices that employees need to be provided. There's a list of federal posters on here. I would encourage that you look at your posting and make sure that they're displayed maybe in a break room, or where employees have access to employee information, and they regularly go to that place and look for labor and employment postings. There's these federal posters. We've talked about the Fair Labor Standards Act. We talked about FMLA. The FFCRA has a notice that was required, and then that EEO policy, the very first one, is basically centered around Title VII and discrimination. So those should be displayed. And then, of course, don't forget about those state law posters. The state laws do have particular posters, and Wisconsin does have a list of posters. And again, it's based on the number of employees, so you'll want to look those up and figure out what posters need to be placed. You can get those for free on the agency's websites, but we also recommend best practices to maybe have a vendor that is a poster vendor, and they can send those to you, so you know you've got the most up-to-date posters. And a thing to note is posters and labor and employment laws don't just become enacted on January 1st. They can be enacted at any time during the year. So that's why a poster service is sometimes helpful, because they send them to you when things change throughout the year. So if we want to pause before we go into the next section, I'm not sure if there's any chat. I don't have the chat box up. If there's any questions, happy to answer them that may be related to the labor and employment laws.
Hi, Kim. This is Carrie. We don't have any questions in the chat at this time.
Perfect. Okay. Well, then I guess I explained everything great. So I also wanted to talk about employee files and what a lot of times when we're talking about the employment process, what should be kept in employee files and how should employee files be maintained. And so let's spend a little bit of time on employee files. But first, why are they important? You heard me talk about the labor and employment laws. Well, a lot of this information in the employee files is required by law. So again, that record retention policy, knowing what needs to be kept and for how long is important. It also assists you in understanding and managing your people and your human resources. You've got information in those files that may talk about performance or compensation, all of that, titles and things like that, promotion opportunities. If you don't have those records, you can't go back to those and understand what was agreed upon, what's our goal for the future. So it's a place to document. It demonstrates compliance. So if you ever were to have a claim or a legal proceeding, if you have the documentation and you're demonstrating compliance with those labor and employment laws, it does show good faith there that you are, an employer of compliance and hopefully that employer of choice that we talked about. And then the next thing is it really does document your employment decisions. So if we think back about discrimination and or when I said equal pay, if you're looking at your workforce and you've got individuals in similar positions and they are paid differently, as you recall, I said, document the reason why. Is it because of performance or they've been with your practice for over 10 years? And so, of course, their compensation is going to maybe compound as opposed to other individuals that are newly hired. Do they have an educational or a training requirement that moves them into a different maybe pay eligibility? So documenting those employment decisions so you can go back and remember why and or defend yourself in any legal proceedings. And then, finally, it does protect the organization and employees. And so employees, it's my thought as an HR practitioner and as best practice that employees should have access to their files and or be able to feed their files. If they get a thank you note or a kudos from a patient or they have training that they went to, they certainly should be able to provide it to their employer to put in their employee file to show and demonstrate some of their commitment and some of the successes that they've had. So I would say that it protects the employer and the employee as well to document some things in those files. So let's talk about what may be in an employee file. Some of these may be obvious to you and some things may not. So whether your employee files are electronic or they are, paper copies, one, they should be stored in a secure manner and confidential. If they are paper copies, and they should always be locked up and one individual or individuals who have access to the key. If they're electronic files, that access should be set up and you should know who has access and who should be able to view what information electronically. But here's some of the key things that go in the standard employee file. Your recruiting documentation, such as your resume, your application, anything, letters of recommendation, those type of things would go in the employee file. Your job description. Now, a job description is not a requirement of the law, but as a best practice, I would say that it makes sense to have a job description that's accurate and that depicts the employee's position. You remember we talked about the Americans with Disability Act, and a job description helps document what's an essential function. So if an employee asks for an accommodation, you can go through that job description and realistically talk about what do they truly need to do to be able to function in their job. So a job description potentially could go in the employee file. And again, I would say best practices, employees should have access to those job descriptions, be able to have a copy of them or even sign them and it's part of their employee file. The other thing that may sound obvious is letters, terms of employment. So your offer letter, information about the position, if they're promoted, if they have a change in title, you may call those payroll action forms or status change forms. Those are things that should be in the file. And obviously the most recent one that depicts what you're paying the employee should be in the file. Pay information, compensation information, obviously makes sense. What is the employee paid? Is it an hourly rate? Is it a salary? Are they exempt or non-exempt? We talked about that under the FLSA. Are they eligible for overtime? Your employee, in any of those employee records that support pay, should be in that employee file. Policy acknowledgements, handbooks, harassment policies, safety training, anything that you require employees to sign or think that they should acknowledge, those should be in the file. And sometimes, if it's an electronic file, those can be pushed out through HRIS systems and they can be housed electronically, but it's an acknowledgement of things that you want them to know and understand about your organization. Performance documentation, your performance evaluations, your goal setting, any of that type of information should be in the employee file. And that goes hand in hand with disciplinary documents. So if there is any verbal warnings or written warnings or disciplinary action that needs to be placed in the file, it should be kept there. And again, I think employees should have access to this standard file that we're talking about, and that's on this screen. Training information, training documents, courses that they've completed, successfully completed, certifications that can go in the file. And then lastly, that separation documentation, anything such as letter resignation, documents around any involuntary termination, that type of information should go in the employee file. So this is all what's standard in an employee file. So we often get asked as HR professional, what else should go in a file, but maybe separate. So we've got another screen with information that's probably a separate file. And if you are the sole practitioner and the only person that has access to this file, this may not be something that you need to separate out. But I would say that employees and other individuals should not have access to this. This is for the person that administers HR, the person that manages the employee files. That's the individual that should have access to this information in a separate file. And it's information about their EEO classification, so their race and ethnicity, background screens, drug screening results, that I-9 information, so that's sensitive information on there that has their date of birth and their social security. It's got potentially, if you save the supporting documentation, it may have their driver's license or social security number attached to it. Of course, medical records, the elections that they choose for the medical benefits, any leave documentation, anything related to workers' comp, that would all be separate. Child supports and garnishment. If you have an employee that has any garnishments coming out of their paycheck, that should be held confidential. Litigation documents, if sadly you're ever subpoenaed for because an employee is going maybe through a divorce of child support or any litigation, that should not be part of their standard file. Investigation records. So what this means is if you had to do an investigation and an employee was involved in it, this is your notes and records. It's not maybe the conclusion or the disciplinary actions that would go in the employee file, but your investigation of a concern in your organization or in your practice. And then finally, probably the last one would be a verification of employment or a VOE. So if somebody's applying for a mortgage or anything like that, and you're certifying that you're the employer and you've got that sensitive information, that should go in a separate file as well. So if you think about what should be held confidential, it's anything that has sensitive data that doesn't really have anything to do with the role that they're performing for you at your dental practice. Moving on, let's talk a little bit about onboarding and offboarding and why they're important, and maybe some tips for you as you go through that process. So why is onboarding important? And you may ask, what is onboarding? It's really, bringing employees into your organization. And incredibly important. One, as you've heard, all of the compliance and risk concerns related to the labor and employment laws and the forms that you have to complete. But employees are your biggest asset, and they're a resource that you want to protect, and they're a resource that you want to come on board and be successful. So if you think about your onboarding process or your orientation process, I would really suggest that you go through and decide not only the paperwork and the compliance piece, but what does an employee need to be successful in your practice and be able to be a contributor to your organization. And that really should be involved in your onboarding practice, whether it's learning about, the safety protocols, how to treat patient information, your office hours, anything that's important to them being successful in their job should be rolled into potentially that onboarding process. And that doesn't mean it's all day one. It may be, over a course of several days, several weeks, and then coming back and understanding that the employee that's new to the organization knows what's expected of them and knows where to find information and resources to help them be successful. And then really, the last reason to really document and have an onboarding process is so that all employees have the same experience. You want people coming in having the same experience so they can be successful, and that they're out in the community talking about what a great place your office is to work, and this is how I was onboarded, and this is how I got successful and was able to get up to speed quickly, and being able to provide value to the organization. So that onboarding is very important. So what's some key things that should be part of onboarding checklist or process? As I said, it's that paperwork. It probably starts with, your W-2s, your federal and state tax forms, setting an individual up in payroll, whether it's with a payroll provider or internally, those I-9 forms, getting that emergency contact information, benefit information, and then any other forms that you collect. And then getting that employee acclimated to your working environment, and to the people that they should go to ask questions if they don't know or don't understand what they need to be working on to be successful. So then let's talk about offboarding. And some people are like, what's offboarding? And really, it is the unwinding of your employment relationship. So the separation of an employee, whether it be they are retiring, it's a resignation, or it may be involuntary, you've chose to separate that employee. There's ways to go about it, and obviously, we recommend a checklist and or a process being documented so that careful consideration of exiting an employee takes place as well. So some things to think about when an employee leaves the organization is, how is unemployment going to be handled? Is there going to be severance if you are terminating somebody? Is there a practice of offering severance, and what forms and protocol need to take place? Is there COBRA notices? And we talked about if there's group health insurance, there's probably COBRA notices that need to go out. Who's going to send those, and how does an employee know, what that means to them? When is final pay being calculated, and when is insurance benefits being cut off? I like to talk employers through that and make sure employees understand what to expect in the transition. When will my benefits end? What is my final pay going to look like? Am I going to be paid out for any unused PTO? Those type of things, and having those conversations and or checklists and information to provide an exiting employee. And then you have to think about removing individuals from your systems and or your email, your patient information, and internally and externally announcing, somebody exiting the organization. These individuals may have a relationship with some of your patients, so how is that going to be communicated, and what should be communicated? And then we did talk about that there's different reasons for separation. Obviously, voluntary and involuntarily separating an employee have different processes, and so I would suggest that before you get into a situation where you may need to separate an employee involuntarily, that you do think through what do I really need to do, to ensure that that individual is being exited with respect and dignity, but also that we are, managing our business and things are moving smoothly. timing of a separation. And if an employee has provided their resignation letter, they're probably going to tell you the time frame in which their last day is, but there's obviously some negotiation there. If you don't feel like you need that individual to stay, you can certainly talk through the change of that time frame. But if you are separating an employee involuntarily, I like to counsel employers to look at maybe when does the insurance terminate? And so the worst maybe thing you can do is terminate somebody on the last day of the month, and then their insurance terminate that day, and they have healthcare issues and they can't access their insurance until they go through the COBRA process. So that timing and that consideration is important. And then who needs to be included in the process? Is there somebody that needs to witness it? Is there conversations with the employee from an exit perspective, and then that information sharing internally and externally? So those are things I would consider in an offboarding process for employees as you go through kind of the steps of voluntary or involuntary. So we have shared a lot of information and spent some time talking about key labor and employment laws. And we are at that time where questions can be asked and some more definition around things. Again, if it is specific to your practice that may be confidential, happy to answer those offline. But if you've got some questions about the things we talked about here today, happy to answer those. Is there any questions in the chat box?
We have not gotten any in the chat box.
Okay, well, great. So I really want to thank everybody for spending time with myself and on BizTalks, and I wanted to leave you with some places to go and search for data if you have a labor question or concern. Obviously, there's professionals out there like myself that answer labor and employment questions, but if you want to go and search online, I would not say Google is your best place to search, although you can probably put it in there and it may lead you to some of the websites, but the Department of Labor website is probably the best place to go. It can be challenging to review that information because there's a lot of legal information in there, but they do have tips for employers, and you can scroll into the different acts that we talked about there. Also, the EEOC's website, and then of course your Wisconsin labor and employment website for anything that would be related to your state. So that's a great place to start and try to sift through some of the information and look at the free resources that are out there for employers to understand labor and employment laws. So with that, I will turn it over to Candace and/or anybody else on the team that's presenting today. And I want to thank everybody for their time and attention, and wish you happy holidays. And let's hope 2020 is our 2021 is a much better year than 2020 as it relates to COVID and pandemic.
Hey, Kim, we did have a question come through.
Okay.
Stephen mentioned, he says, you mentioned info about background and credit checks.
Mm-hmm.
I don't know, Stephen, if you can elaborate on that a little bit more, what you'd like him to touch on.
I know that I shared that it should be saved in a separate file. And so if you're pulling background screens on employees as well, and you're using a third-party vendor, there is a law called the Fair Credit Reporting Act, which makes you think credit, and it's really not. It's related to credit, but any investigative reports that you pull on employees from a third party and you're making employment decisions, there is some requirements around the Fair Credit Reporting Act to notify an employee of any pre-adverse action. So you're making a decision that may impact their employment, or if you decide to hire them, there's some notices that need to go out. So if you're using a third-party vendor for those credit reports, I would, connect with them and talk about any adverse action. But those credit reports or background screens or drug screens are a piece of the puzzle for making employment decisions, but they should not be the sole decision maker unless it has a bona fide business reason or a reason around the job to eliminate somebody from working in your organization. So, Stephen, I'm not sure if I answered your question related to background and background screens, but if there's more elaboration, I'd be happy to.
He did expand a little bit more. Are there limitations on what you can do? And what if you are doing this yourself?
So if you're doing it yourself, that makes me assume you're doing a Google search and things like that. And you know, there's public data out there and there's public records, but again, there are limitations on decisions that employers should make. And if you're making an employment decision based on a background screen, then it should have a reason why that person should not be employed in your organization. Credit reports, I probably wouldn't see those in a dental practice unless somebody has cash handling requirements, and that could be slim. And then the drug screening, there I would say you should have a policy around that. What you know, if an employee is tested for pre-employment or post-accident or random testing, there should be a policy, and that policy should be followed. And that drug screening should be done through a third-party vendor where there is a medical review of that drug screen. So I would say that policies and procedures should be documented around decisions related to background screens and drug screens.
Okay, one more question came through. For those people working for chain organizations, who is responsible for keeping all of this employee records?
So that's a great question. So the employer of record is responsible. So if you think about who the employer of record is, where does that employee get their paycheck? What's the EIN? Where do they fall into? That is considered the employer of record. If you are under a professional employers organization or a PEO, that is the employer of record, and they are responsible. So if we're talking about that employment relationship, or if you're using maybe temp agencies in your workforce, that temp agency is the employer of record. That does not mean that maybe there's some joint relationship there with the employers, but whoever is considered that employer of record who's issuing that paycheck is ultimately responsible for that data and gathering this information. Any other great questions today?
That is all from the chat.
Great. Candace, I want to turn it back over to you. I think you had some closing comments.
I just wanted to say thank you to you, Kim, for a great discussion today. I think a lot of the information you shared hopefully was super helpful for our members. Again, this was recorded, so if you joined us late because of technical issues or you got stuck with a patient, the recording should be posted and I can share it on Monday. And I will be sharing all of your continuing education credits come Monday. So if you joined with a fellow colleague or a spouse and shared the link, please just make sure you share that information with me so I can make sure everyone gets their certificate if they joined us today. Otherwise, I think we're good. Thanks, CLA team, for a great presentation. And I hope everyone has a great weekend and has their snow blowers ready. We look like we should be getting some snow here in southeastern Wisconsin.
Thank you, everyone.